Well, hello, everyone, and thank you for joining. I'm Jill Bloom, Group Publisher of Building Enclosure, and welcome to our podcast show. It is always an honor to have with me Trent Cotney, partner with Adams and Reese. Trent, thank you so much for joining me.
Hey, Jill, it's great to be here.
So, Trent, there's always some really exciting and interesting topics happening in the legal world. As you always know, it keeps your phone ringing all the time. But what we were just talking about before we got on, it sounds like there's been some recent Supreme Court decisions that have happened that everybody needs to know about. What's been happening?
Yeah, so there's a couple of decisions, the Loper case and the Corner Post case, both of which came out here within the last few weeks. I think one was end of June and the other was 1st of July. And both of those decisions directly affect executive agency action and the interpretation of their provisions. So to give our listeners some of, historic legal precedent, there's a famous decision that has been around for 4 decades or so known as the Chevron decision. And in that case, it says that agencies, the executive agency, has deference for determining its own interpretation of anything that's vague within its governing rules or statutes, right? So the agency has the ability to interpret its own vague provisions. The Supreme Court in both of these decisions, and the Loper-Bright case and in the Corner Post case, said, look, that's no longer going to happen. The courts will now exercise independent judgment over that interpretation, okay? Which historically that belonged to, the agency that was the subject matter expert.
Meaning like OSHA or the EPA?
OSHA, EPA, FTC, any Department of Labor, any of those federal agencies. So what does this mean for, the construction industry? It means that there have been a whole host of challenges. Basically the floodgates are open. Ton of regulatory challenges. I've already seen some that have come in and appeals that I'm currently involved in saying, look, the agency cannot interpret its own rules if there's nothing there. We need to look to the courts to take a look at this and to tell us what is the common sense meaning of some of this based on how it's worded. These decisions are not atypical from what we've seen out of the recent Supreme Court. The Supreme Court is a very conservative leaning, a more strict interpretation type leaning, and this jives with that. So we've already started to see some challenges to agency action, both during and post COVID, and now this just piggybacks off of that, right? So as we move forward, it's going to put tighter constraints on executive agencies, which honestly I think is a good thing for contractors, trades, in the construction industry. Because for a while there was just sort of unchecked power, and our whole system is built on checks and balances. And I think this creates that extra layer that's needed.
Well, I've heard a lot of people feel that a lot of these agencies are being weaponized. And so it sounds like this is going to be helpful. Would you agree with? It sounds like you agree with that,
Yeah.
Trent?
Yeah, absolutely. It's hard to excel or defend yourself in a system that interprets its own rules, right? It would be a lot easier to have some sort of oversight and help interpret things that aren't plain, right? Because in looking at a lot of these regulations, it doesn't matter whether it's OSHA or any executive agency, you see holes, right? And there is stuff, if there weren't holes, I wouldn't have a job. Right. So that's the problem. And you need a court to be able to determine that, because that's their role is in the judiciary. So I agree with the decisions. I think it's the right way to go. And I do think, agency action needs to be checked a little bit.
So does that lengthen the process and that it takes to get the rulings?
Yes and no. I mean, we all know the march to justice is incredibly slow, and that's not all lawyers' faults. That's a lot of times either the judicial system or the agency system itself. I do think that this will raise additional challenges. So depending on how rulings are, you may see if it's an adverse ruling, you can absolutely say, look, your interpretation of these rulings is flawed. We need additional judicial oversight to take a look at this. So I do think it will increase the number of appeals, which we've already started to see.
Okay.
Again, I don't know if that's necessarily a bad thing. I think it can be a good thing because it gives you a fresh set of eyes to look at it.
Oh, absolutely. That sounds great. And the other thing too, Trent, I wanted to talk to you about was the one-to-one content, consents that we talked about in the past with Anna Anderson. It sounds like there's some other things happening that are coming up. What does everybody need to know? Going back to that one-to-one consent, and what does that mean?
Yeah, so the Telephone Consumer Protection Act, the TCPA, recently had a ton of amendments, and this deals with everything from, calling customers to robo-dialing to, it goes even further than that, right? Anything that deals with solicitation. And there's been a variety of rules that have come into place, some of which have been staggered. January 27th, 2025, the one-to-one consent requirement goes into effect. And what that means is that you have to have consent of the actual person that you're calling, and that consent needs to be obtained by the actual business that is making or causing the call to be made. So historically, you could have, a parent company obtain consent for 25 different subsidiary companies, and that would be fine. Now it is a one-to-one requirement. So what are we recommending for, anybody in the construction industry? Well, as you know, Jill, big believer in being proactive rather than reactive. So we're suggesting that you get a standard operating procedure in place, that you get a consent checklist. And this checklist has got, 7 to 10 different things on it, but in there, you've got a conspicuous disclaimer on your website, on your opt-in, on your, anything like that, where you are specifically getting that authorization to make that call or to have that communication. Okay. You are making sure that it is not a condition precedent to selling goods or services. You can't tie one with the other. It's got to be independent. Okay. Like I said, it's got to be your specific business and the actual party that's called. And the most important thing is you've got to be able to show that you've actually obtained the signature of the called party. So this can be done electronically or digitally. We all receive those text messages where we can opt in. But the other thing that I would kind of advise our listeners is if you outsource this, if you use external marketing, if you're using aggregators, if you're using external people, make sure that you check your vendor agreements and that you have access to the signatures and consent forms, because we defend a ton of these TCPA cases, both on the federal and state equivalents. And sometimes these companies are overseas. You'll never be able to find them, right? So hire reputable companies to do this stuff and make sure you have access to that critical documentation.
Wow, yes, very, very good advice, Trent. And I know that we'll be talking about this more as time goes on, because January 2025 is around the corner.
Yep.
So like you said, hopefully we can help everybody be proactive and not reactive.
Mm-hmm.
Well, Trent, thank you so much for your time. Is there anything else that's making your phone ring we should touch on real quick?
I think there's some anxiety out there just generally with, where we are with the economy, where we are with the elections. Construction still remains incredibly strong. Backlog still remains strong. But, I'm always, anytime I talk to any contractor trade, anybody in the construction industry, I always tell them, just keep a close eye on your AR, make sure that it's the customers you don't take that make you successful. And I want our listeners to just let that soak in a little bit. And what I mean by that is vet your customers, vet the people that you're going to do business with. Construction, as big as it is, it's word of mouth still. We all know who's a good contractor and who's not. We all know contractors that like to stiff subs. So what you want to do is you want to make sure that you are contracting with someone that is going to be a good partner with you, that is going to, work with you, and watch those accounts receivable.
Great advice. So Trent, if anybody has any questions for you, where do they find you?
Sure, they can hit me up on social at Trent Cotney or email trent.cotney@arlaw.com.
Sounds great. And thanks again, Trent. And if anybody has any questions for us, it's roofingcontractor.com, wconline.com, or buildingenclosureonline.com. And while you're there, make sure you sign up for all our free content, especially follow us on all our social media channels so you can stay up to date on all the great interviews we are doing, especially the great nuggets of legal information that we get from Trent. But most importantly, stay safe and healthy, and we can't wait to talk to you soon. Thanks again, Trent.
Thank you.